Well, there she is. Before we start, have you respondents, attorneys decided how you want to split up your time?
Yes, Your Honor. I think I've been elected to present for everyone.
Oh, that works. Okay. All right. Flowers, you're up.
Thank you, Your Honor. May it please the court. Angela Flowers of Kubicki Draper on behalf of Security First Insurance Company. And I would like to reserve 5 minutes of my time for rebuttal. As the court mentioned, there are 3 cases on the calendar today which have been consolidated because basically they involve the same issues. For simplicity's sake, I will refer to all the respondents as plaintiffs jointly. The central issue in the case involves whether or not a pre-suit notice provision contained in a statute enacted in 1921 addressed to homeowner property insurance litigation, which was a comprehensive legislative enactment designed to address an existing insurance crisis in first-party property market. The question will be whether or not subsection of that statute, which involves pre-suit notice requirement, is unconstitutional as applied to the facts in these cases. In the trial court, Security First moved to dismiss each of the plaintiff's complaints on the ground that they had failed to comply.
Flowers, actually, to be fair, the allegation, the position of the respondent seems to be that not that the statute is unconstitutional, but that it is prospective only.
In order to get to the conclusion that the statute is prospective only, the plaintiffs do so by arguing that not the pre-suit notice provision, which was the basis for the motion to dismiss, but that other provisions within the statute, which is 627-70152, that these alternative provisions involve substantive matters which cannot be applied retroactively.
Well, they're not really alternative provisions, are they? They're part of the statute, that the notice requirement, that includes the notice requirement. And in fact, those provisions are fairly dependent on the notice requirement, it seems to me. For instance, the attorney's fee provision, the requirement that the insurance companies develop a procedure for evaluating these claims within the 10 days, I guess. I don't think the respondents have argued that the notice requirement is isolated. You seem to have made that argument, but they're arguing that the statute, the amendment, or the law that created the statute is prospective, full stop.
Correct, Your Honor. And they argue this globally based on a review of the entire statute. And what Security First has maintained is that this case and the statute is not unlike the statute that the court examined in the Citizens Insurance Company case versus Trapeo, where the court was looking at the sinkhole statute, which contained both a procedural section directed to stay of proceedings and also substantive sections which were directed to neutral evaluation. And when the court examined that statute, following standard rules of statutory construction, which require that a statute be held constitutional whenever possible, this court recognized that the 2012 amendment to the sinkhole statute, which added the stay provision, was a procedural provision, and that applied in that Trapeo case, even though the neutral evaluation provision, which was a substantive provision, could not be retroactively applied. The court looked to the earlier 2010 version of the statute because that's the one that was in effect when the policy was issued. So let me just give a couple of propositions.
But before you get to that, Ms. Farr, maybe I'm looking at it a different standpoint. Before getting into the actual merits as to whether it applies prospectively or not, isn't this case, this is a first tier cert petition. And because it's a first, so help me out with this, because we are dealing with a first tier cert petition in which now you seek to quash an order denying motion to dismiss a first party property lawsuit brought by the insured. Now the trial court, bear with me because I'm looking at my notes right here. The trial court rejected your argument that that's the statute imposes pre-suit notice obligations. So would you agree with me that this case presents, it's basically a first impression with respect to the interpretation of this new statute, which is less than 1 year old. So I guess my question to you, how can this be a departure from the essential requirements of law? If what is the clearly established law that was departed from, if you're dealing with a brand new statute, and this is a case of first impression. So procedurally, help me out with that, Ms. Flowers.
Right. Thank you, Your Honor. So security first position that subsection 3, which is the notice requirement provision, that it's procedural is the key to the certiorari jurisdiction that we've asked the court to exercise. Because when you're dealing with just a merely procedural provision of a statute, the court is able to implement that type of ruling in a first-tier cert case, even though there hasn't been any case law interpreting substantive provisions of the statute. So let me lay the framework that I'd like to suggest to the court. And I'm going to start with first pointing out that the legislature was very careful in the way that they drafted this statute. The legislature was clearly aware of the Menendez case, which the plaintiffs' respondents rely upon. And I want to make it distinguishable to this court by pointing out that when you read Menendez, what's very important to observe is that in the Pip statute, which Menendez addressed, the pre-suit notice provision was contained in a comprehensive provision. It was subsection 11 at the time that did not do what this statute does. The pre-suit notice provision in Menendez did not simply set up a procedure for pre-suit notice, which serves two procedural purposes that I'd like to address in a moment. What they did in Menendez is they wrote one comprehensive subsection 11. And within subsection 11, the legislature set up a pre-suit notice statute that was tied to a new definition of overdue benefits, and that was tied to a change in the substantive right to attorney's fees, as well as when suit could be brought. So we have this is a fundamentally different statute. It's not drafted anyway the way that Menendez statute was, and there's a clear purpose for that.
But if I may, Ms. Flowers, in this case, couldn't you argue that the notice provision in our case does delay the right to bring suit?
So what the notice provision, to the extent that there is a de minimis delay of 10 days under the notice provision, there is no substantive vested right in a plaintiff to file a lawsuit on a particular day. This de minimis delay, if it's going to be claimed, is a delay that occurs that is totally within the control of the plaintiffs, because the plaintiffs can determine if they want to file.
The notice provision also alters the law with respect to recovery of attorney's fees.
The notice provision,
which is one of the indicia under Menendez to indicate that it's a substantive change rather than a procedural change, and therefore not retroactive.
The notice provision itself, subsection 3, does not have any effect on the plaintiff's vested right to attorney's fees.
Well,
in fact,
does require under 1A that there's a new requirement that in the pre-suit settlement demand there must be an itemization of damages and attorney's fees. That's new.
That is new because the statute seems to the fact that the subject matter of attorney's fees is substantive does not mean that this provision has an effect on that substantive right, and I'll explain why. The notice provision is there to serve two purposes. The notice is served, and we're talking just about the 10 days. Let's talk subsection 3 for, if I could just have a few moments. The notice provision is there to provide notice to the Department of Financial Services. That intent is there because the legislature knows that the department needs to be gathering information in order to monitor what is happening with insurance claims and the status of the first party insurance market. This ties to part of the session law to 2021-77, also amended section 624.424.11, which impose certain reporting requirements on the insurance companies, where the type of information that's listed in subsection 3 is being gathered from the insurance companies. This is the only vehicle that the legislature could enact in order to give the Department of Financial Services the parallel information from plaintiffs so that it can perform its governmental duty of monitoring the insurance market within the state, what the trends are, and anticipating what the citizens of Florida need in order to make sure that there is affordable property insurance available to them. That's a procedural aspect of subsection 3. The second procedural,
the thing is that you don't need to make a condition precedent that would cause the plaintiff's suit to be dismissed if it's not satisfied in order to accomplish that purpose.
there is no other vehicle by which a plaintiff
why not have the insurance company make that report? Why not just say when they file the complaint, they should submit this information? The notion that the only way they can get this information is by a mandatory 10-day pre-suit notice on pain of having their suit dismissed or losing their attorney's fees, right to attorney's fees under a statute. That's just not true, Ms. Flowers.
The information is already being gathered under the statute that I mentioned from the insurance company, but that's from the insurance company's perspective. What the studies in the legislative history have shown is that the insurance companies are not receiving key information prior to lawsuits being filed that enables them to effectively adjust claims. So the second aspect of subsection 3 is that this information is being provided to the insurance company. What legislative investigation showed, perhaps for the first time ever, where the insurance company receives the type of information that enables it to determine what is a meritorious claim.
And the insurance companies write that into their policies?
They have.
Okay.
And although I don't think we need to discuss subsection 4 right now, because I want to continue for a moment to stand alone on 3. But subsection 4 is a remedial provision which codifies those requirements that are in the insurance policy already that aren't being complied with, and that because there are what they call, bad actors out there in AOB situations and different public adjuster situations which are thwarting that opportunity to enforce the policy that way, because once you hire an attorney, a lot of the rights under the policy, such as investigating the property, are now impeded by the fact of the attorney's involvement in suit. But I want to wrap up with subsection 3, because subsection 3 alone, with its simple procedural requirement of filing a notice of intent to initiate litigation, if there were no other provisions in the statute, it provides a remedial opportunity for claims to be settled quickly so that insureds do not have to suffer the delay of litigation, and so that insurance companies can recognize meritorious claims, settle early on, and not be subjected to costly litigation. So subsection 3 was very carefully crafted by the legislature to be able to stand on its own as a separate procedural or remedial device that serves that purpose of pre-suit. Now, the legislature dug a little deeper and wanted subsection 4 to set up a remedial regulatory process by which rights that already exist, would be re-implemented in a reevaluation. But that's apart from subsection 3.
So you would concede, I suppose, that if we disagree that we can read subsection 3 in the abstract, apart from reading the whole statute and trying to make sense of it, then your argument would fail.
Not necessarily.
Your argument depends on our taking subsection 3 in isolation.
No, that is certainly the issue which I think is before the court on certiorari. However, because the other issues just haven't been, they haven't been fully developed by the court below. But if I can quickly, I do want to touch on both subsection 4 and subsection 8 within the context of recognizing, and I think that plaintiffs' respondents have recognized that subsection 3 standing alone does not impair any substantive right of the plaintiff's insured. It doesn't change their cause of action, under their insurance policy. It doesn't change any dime of the damages that they're going to be able to recover under the insurance policy. If anything, it has this slight de minimis delay, which does not touch on a vested right, since there's no vested right to file a lawsuit on a particular day, and they're completely in control of when they file it. So I don't think that they disagree that subsection 3 is purely procedural. And I don't think they disagree the remedial purposes, which are evidenced within subsection 3. So if we have this intent for this remedial law, which causes no substantive impact on the insureds, subsection 3, if we take it standing alone, should be enforced as intended by the legislature in every case that's filed after July 1st of 2021. Now, the legislature wrote a much broader statute. And as I said, these haven't been fully developed below in the court because the motion to dismiss was not based on these other provisions. But when you look at the substantive arguments being raised by the plaintiffs, they fail even as to whether or not the statute should be held unconstitutional as applied to them because of subsection 4 and subsection 8. And subsection 4 is briefly, as I said, a codification of existing rights and duties. So subsection 4 alone doesn't impose or take away any vested rights. There is a provision within subsection 4 where it's anticipated that the plaintiff will have presented a demand for judgment, and it will have stated an amount that they'd be willing to settle for. But that's not invading a substantive right, asking them to give a piece of information that they know already in preparing in having made the claim, and then in preparing to file the suit. So under subsection 4, though,
getting back to something that Judge Kazam raised, I don't think you ever really got to the answer. What would you say is the essential body of law that we are departing from, that the court below departed from in finding as it did?
That concept that if there's a statutory condition precedent, that it is.
Doesn't the law on statutory conditions precedent, if anything, lean the other way?
In terms of certiorari jurisdiction, the case law, certiorari provides a path for review at the motion to dismiss stage of cases that are trying to go forward without the complaint having pled compliance with the statutory condition precedent. We see this in the medical malpractice cases, which involve the pleading of a condition precedent. We see this in the sovereign immunity cases, which is also a situation where notice is required. We see this in the non-joinder statute. All these situations involve types of pre-suit notice that is required in order for the complaint to state a cause of action and to be able to go forward. So these are
Judge Barbas analogized the med mal statutes, and in Menendez we're dealing with the Pip statute. Now we have this statute, and in each instance, the rulings that went before us found those to be substantive components and not procedural, and therefore not retroactive.
Well, I believe there's a mix on that, but even if they are found to be substantive provisions, a remedial statute can be applied when it involves substantive issues. It just can't affect a pre-existing vested substantive right, but remedial statutes can and do involve substantive issues. And that doesn't mean that they can't be applied retroactively. The test is whether or not they are going to encroach on vested rights, or that they're going to create a new obligation contrary to some vested right, or impose a new penalty. And so for that,
the general law is that there is no retroactive application for a statute like this. And can you point me to anything within the statute that would indicate that this is supposed to be applied retroactively?
Well, yes, I can, to the extent that we'll start in any matter of statutory construction, with the plain language of the statute. And the statute itself has 3 points at which it addresses the concept that the statute is to take effect immediately. So the first one is that in subsection 1, it talks about application of the statute, and it talks about it's applying to all suits. So it's applying to all suits on the date that this statute goes into effect. It then, in subsection 2, in the definition section, and talking about who is a claimant and defining a claimant, it defines a claimant as someone who is filing suit. And then, of course, that ties together with subsection 3, which is the notice provision, which uses the words that it's establishing it as a condition precedent to filing suit. And I would note for the court that in the Menendez case, the court, based on the Pip statute, labeling the notice provision as a condition precedent, conclusively concluded that there was intent expressed by the legislature merely by using these words, condition precedent, that there was the intent that it was to apply effective immediately. And then so we don't need to reach the other vehicles for determining legislative intent, but if we do, we can look at as well at the preamble to the session law, which sets forth the intent. It's found as well in the bill analysis and fiscal impact statement, which talk about the urgency with trying to address this crisis that we have with the first party insurance market in Florida. And then finally, if we look at the path that the bill took through the legislative process, we see what provisions it rejected. And at one point, the Senate the legislature expressly rejected a House bill that would have inserted language that said the statute did not take effect except for policies enacted on or after July 1 of 2021. So
Ms. Flowers,
I'm pushing up on my time. Yes.
Yeah, and you are, and I wanted to raise one question for you. You are couching this, one of your arguments that you've made is that what the respondents have done is, or the plaintiffs below, were challenging the constitutionality of this statute and needed to notify the Attorney General's office. And of course, they have said, no, that, they're not challenging the constitutionality. They're arguing about whether it's applied retrospectively or retroactively or prospectively. And you have suggested that there's legislation coming forth in this special session that's coming up next week that might clarify that issue. So let's assume, for instance, that, and I've looked, there's no such bill at this point. But let's assume, and that's assuming that's appropriate legal research on my part, but let's assume that the legislature does clarify this in your favor and says this statute was meant to apply to all cases, retroactively to, et cetera. What happens then if we think, or the respondents think, that that is unconstitutional?
Well, there's a long history of the legislature revisiting statutory
I get it, but
enactments.
what do we do procedurally, I guess is what I meant to say.
Procedurally.
Yeah, where are we at that point in a case that has been brought and briefed without notice to the AG's office on the basis of a statutory interpretation versus statutory constitutionality?
Right, so we're back to that question of whether or not the court will address subsection 3 as its own separate subsection.
Well, yeah, no, but that's not the question. The question is, what do we do procedurally? Do we ask you to rebrief it? Do we notify the AG's office? What do we do? Because this case comes up on the basis of proceedings below that have already occurred. I mean, it's not final. It's not a record on appeal precisely. Do we deny it without prejudice and send it back, and you guys can duke it out over the effect of the new statute? What do you suggest we would do?
Well, I think the court had 3 options. The first one, of course, would be to dismiss based just on subsection 3 alone, or if the court decided it was appropriate to look at the other subsections to determine the characteristic of subsection 3, then I think we absolutely should have the opportunity to rebrief the issues and represent them to the court. And in terms of the notice requirement, the rule is clear that it's the party who wants to make a constitutional challenge that must advise the Attorney General, and that has not been done in this case.
They have not made a constitutional challenge at this point. What I'm suggesting is that if the legislature were to issue, enact a new law that clarifies this one and says it's intended to be retroactive, that then would suggest the possibility that the new statute is unconstitutional. And at what point, when do they notify the AG?
Right.
At that point?
Right. So I believe that there could be some procedural context in which the court should remand the case for further proceedings in light of any legislative amendment, so that the Attorney General.
Writ petitions, we
I know.
don't remand.
I know. I
So
know.
I think you guys
Well,
might find yourself back in the circuit court too sweet.
So perhaps we could move for a relinquishment of jurisdiction.
Okay. Well, there's no relinquishment of jurisdiction. I mean, you know this, Ms. Flowers. I'm teasing you.
Just because I've never seen it doesn't mean that it might not be granted if requested.
Okay, you're right. You're right at your rebuttal time if you want to.
Let me just throw this in light of Judge Northcutt's question. This is all supposition that the legislature will somehow focus on this specific statute, and somehow this specific statute is paramount in their mind. You know, obviously, we just have to proceed with the case before us. So I just wanted to throw that in.
Correct, but I did thought that I would not be doing my job if I didn't advise the court of this possibility, and so therefore I provided notice of that.
All right.
I mean, you know, and it's not unreasonable. I mean, there is a special session coming up on insurance, so I get it.
Thank you. I will continue during my rebuttal.
Okay. All right, Mr. Elliott, you're up.
Thank you, Your Honor. Good morning. Please, the court. I'm here. My partner, Amy Ferrier, is just off screen, and Mr. Lopez is on, and I know we have other trial counsel that are watching intently. So I'll start with
no pressure.
I'm sorry?
But no pressure.
No. It's all good. Sorry, we can't be there in person.
Mr. Elliott, can I have you respond to the question that I've asked Ms. Flowers? This is up before us on a first-tier cert.
Yeah. Yes, Your Honor.
Help me out with that, because with first-tier cert, and I know Ms. Flowers, you know, responded in the manner the way she did. What is your take on this?
Your Honor, this may be the only thing that Ms. Flowers and I agree on. I think you do have jurisdiction here. I understand the question. I understand the 4th District dismissed one, saying, well, there's no issue of settled case law. But I don't see how we can distinguish this from the pre-suit notice jurisdictional ground in the med-mal cases or in the other pre-suit notice context. And the med-mal cases come up for pre-suit on cert all the time. So to say there's no settled law, which is what the 4th District paneled in that one case under this statute, I think is too narrow.
Frankly, the Supreme Court over the years has gone back and forth on this question, you know, from I guess it was Cocklamanos or one of those that said, oh, you can find settled law in a statute versus, you know, so I mean, they're kind of back and forth. I get that. So.
And really, if the standard is, you know, there haven't been any cases, actually there have been cases. I mean, we've got this batch of cases. There are other cases. There's at least one other case I know of pending in the 2nd. There are other cases in the trial court that have reached differing decisions. And we have a slew of federal cases. A slew is maybe, there's probably 5 or 6 that I'm aware of federal cases that have addressed this issue in written opinion. So this issue is out there. It has been addressed, so I don't think it is that novel. I do think certiorari would be appropriate here, and you know, obviously it's still a writ, it's still discretionary with the court. But I would think with the cases that are backed up and the trial judges that are looking for guidance, it would be a good idea to go ahead and address this. So I'm with Ms. Flowers on that. Now let me depart because I'm not with her on everything. You heard a lot about look just at Section 3. Just don't look behind the curtain, as they say in the movie. Just look at Section 3. But we can't do that. Menendez and Borden and other Florida Supreme Court cases we've cited, page 26 of our answer brief in Peyton, say all parts of the statute have to be read together. All parts together. There's no effective response for this. There's nothing in the reply brief about this. And I'll pause for a moment. Security First is not relying just on Section 3. If you look back at their motion, again, look at appendix page 10 in Peyton, they move for a dismissal based on 3 and Section 5. Section 5 is the section that lets you dismiss if the pre-suit notice hasn't been done. So it's not just Section 3, it's 3 and 5. And then you know what? If you're dismissed under 5, then you go to 8 and you don't get the fees. So it's 3 and 5 and 8. They are all interrelated, just like the characters in a Dickens novel. They all come together. It's one statute. You look at it together. So Trapio, this is the same panel that had Trapio. Didn't realize that till I looked at Trapio again, but it's the same panel. In Trapio, that statute, the substantive part of the statute, was in effect long before the policy. No question it applied to the policy. The only issue there was the procedural stay. And this court said, we're going to look at the statute as a whole. That's how the procedural stay said it was ancillary to the substantive stuff. Because if it had just been a procedural stay, that was the only thing, and you looked at that in isolation, it would have violated the rulemaking power. So the legislature couldn't have done just a stay. They can't do just a notice here and look at it in isolation. This is all looked at together. And then when you look at it together, the test is, does the statute as a whole, clearly express an intent to apply to policies already issued as of its effective date? In other words, to apply retroactively. And that intent is simply not here. Again, we cite the Zuckerman case from Florida Supreme Court, says using effective date rebuts retroactive intent. That's what we have. To go to the statutory language argument, the fact that it was in a bill saying it was going to apply to policies that were already out, or saying it was going to apply to all suits filed after, and it was not in the Senate bill that passed, I think shows the legislature, somebody there probably looked and said, oh, we can't do that. It'll be unconstitutional under Menendez. That's probably what happened. Give some credit to some legislative research person on that. But getting back to the language, simply saying it applies to all suits brought not brought by an S&E, all property suits that are not brought by an S&E, that's describing what kind of suits. It has no temporal function in there. I mean, what are we going to say? It applies to 50% of the suits? Of course it applies to all suits. For the temporal guidance, we look at the effective date. That is in the bill. The last section of the bill provides an effective date. And we know that, the claimant definition doesn't add anything, in my view. There's no case cited, and I've never seen one that says you can get that type of intent of this when the statute is going to apply out of a definition. I don't think there's any cases ever said that. And that issue wasn't raised below and wasn't raised in the initial brief, so it's not really something we can consider anyway. But again, I don't think we can get to the preservation issue because it simply is not a meritorious argument. We know that the legislature knows how to word these things because that's what they did in Menendez. Menendez had specific language that said it applied the pre-suit demand requirement shall apply to all actions filed on or after the general effective date, which was June of 2001. So we know that the legislation knows how to do it. And that's one of the reasons why I think when you see the Supreme Court decision in Menendez, they're saying, well, okay, they wanted to apply retroactively. We're going to look at whether that's constitutional. If you look at the third district decision, that becomes clear, and they have this language. You see the effective date of the statute. We don't have any language like that here. We do not have any language other than the effective date is July 2021. That doesn't say it applies to policies. All three of these policies were not only issued before that, they had expired before the statute came into effect. Okay, they were already expired. The claims have been submitted, they've been processed. There'd been a denial in one, I think, and a couple small payments in the others. So this had all gone up. The insurance companies had looked at this. This was not a surprise or a shock or anything. And another example of the legislation knows how to word these things. If you look at our supplemental authority, which is the S&E bill that came out a couple of years earlier, it has language that says it applies to an assignment executed after July 1, 2019. So again, they know how to do this. Furthermore, even if we only look at section 3, it's substantive itself. The notice provision is the first sentence or paragraph, whatever, but then you look, it's got 1, 2, 3, 4, 5 subparts under that. You have to provide an estimate of damages. You have to provide itemization, documentation to support the information provided. So it does impose substantive requirements.
Well,
So
let me raise that, as well, and Ms. Flowers may want to address this when she comes back up. Is that it seems to me that the statute requires the plaintiff to make a settlement demand, and to describe this demand to the department, and the demand has to be dollars. The demand can't be apparently fix my house. And generally you don't do that when you file suit. I mean, you can't, right? You say damages in excess of the jurisdictional amount. Is that substantive to require a party to make a settlement demand?
Your Honor, I would say yes. And
I figured you would.
it's not, but it's not just a demand. They have to work. They have to do work to make the demand. They have to include the estimate. They have to show why they did it. They have to itemize it. They have to produce the documents. This is going to be like a little settlement package.
Well, precisely. That's what I'm getting at. It basically requires the plaintiff to do that 10 days before filing suit.
And that is to go back to the language in Menendez. That's impairing a vested right to file the suit. It is creating new obligations, all this stuff they have to do. And that's all section 3 or paragraph 3 or whatever. Yes, the part about what you have to add and prepare to it, yes. And then you move on to the penalty. If you don't, you get dismissed and you get no fees and you have to file again and pay a filing fee. So it is, even if you look at just section 3 as substantive, and we don't look at just section 3, by law, we look at the entire statute. Okay, let me see let me ask, I've got a couple things I want to wrap up with, but let me ask the court if there are any further questions for me. Okay, then 2 things. Attorney's fees. We'd like to get some for the appeal. We filed a motion, and the point I wanted to make is if we prevail, this is 627.428. We're entitled to a fee when we prevail. We don't have to obtain the monetary judgment, and it should not be a conditional fee. We will have prevailed on the appeal, establish these rights for these policyholders. And while we don't have to obtain a monetary fee, a monetary benefit, we will have, because if this is not dismissed, if it were dismissed, they'd have to pay another filing fee and they'd lose some attorney's fees, but they'd have to pay another filing fee to get going again. So we have will have provided a monetary benefit as well. Okay, so.
And if I may, Mr. Elliott, about
Yes.
your request for fees, you basically made that request, and I'm pulling it up right now. Bear with me. Let me see if I could pull it up right now.
Sure.
You moved for fees under the section 627. I want to make sure that I read it correctly. 0.428 subsection 1 Florida statute 2021. So
Yes.
you made the request under that statute.
Yes.
And so the fact that I see here, .428 sub 1 was amended the same day that 627-70152 was enacted, right? Because it simply added that 627-70152 govern fees in cases on policy like ours. And so I guess my question is that the fees motion that's before us, we deal with the same question of which year applies as to the merits of the petition. Could you address that for me, Mr. Elliott?
Yes, Your Honor. If we are correct, and the court does not, if we look at the statute as a whole, and we are correct, and there's no retroactive application of it, then the appellate fees, just like the trial court fees, are controlled by 627.428. So if we're correct, what I would call the statute that was in effect at the time the policy was issued, and of course that means under Florida law, it means it's a part of the policy, applies to our case, and it applies on appeal as well.
And then the question becomes, and I know there was some, you've indicated whether or not the issue, whether it be conditional fee versus straight out fee. And I want you to address that because my reading of it, it appears that any award should not be conditional. So I want to give you that opportunity to address that.
I agree that the award should not be conditional.
All right.
In other words, it should be, there should be an order. If the court, if we're fortunate enough to prevail, the court should then enter an order saying you're entitled to fees in an amount set by the trial court. And that does not wait for the end of the case. So it does not, it would be unconditional.
All right.
Have I answered that?
I believe you have. Thank you.
Okay, thank you. And then in conclusion, I would say we would like you to affirm. And I know it's a bit unusual for a respondent or an appellee to say we'd like a written opinion, because normally people standing here in this situation are happy to get a win and just go home. And of course, we'd be happy with that too. But there are other cases, again, in this court, at least one that I know of, and in other trial courts for which a written opinion would provide guidance. So we would request that the court is so inclined to do that. With that, I would, unless there are questions, I'll stop talking.
Thank you, Mr. Elliott. Mr. Lopez, anything you want to add?
I think that was very well argued by my colleague, Mr. Elliott.
Yeah, and we appreciate your succinct and erudite contribution, Mr. Lopez.
Thank you.
All right, Ms. Flowers, you're up to rebut.
Yes, thank you, Your Honors. Judge Northcutt, as to your question regarding what if subsection 3 involves substantive issues, what I would again reiterate is that a remedial statute can involve substantive issues and can be applied retroactively in so long as it doesn't do any constitutional harm. So we go back to the.
So, but I mean, am I reading it correctly? Does it require the claimant to make a settlement offer, put together, as Mr. Elliott described it, essentially a settlement package?
Well, not so detailed as a settlement package, you know,
but close, but in that direction.
In that direction. So, what it's requiring are such basic pieces of information that should have been a part of any effective claims settlement negotiations that have gone on so far. You know, the plaintiff has already.
If there have been.
Well, but that's the whole point. If the system was working the way it should work, there should have been a proof of loss. They should have itemized. They should have submitted receipts. All of this information exists. And so this is just a remedial step to put forth, regulations that are going to make the system work, because this is what is needed in order to have an effective first property insurance market in Florida. And so even though it may involve some substantive issues, as I said, it does no constitutional harm. It's not asking for information that's not already in the possession of the insured. It anticipates an estimate if it exists, and then it opens up for any other documents. So it's not interfering with any vested rights. What it's doing is merely trying to bring together the helpful information that the insurer may have never seen till now. And so that the insurer can be presented with this information and have this 10-day window to try to settle the case if they find that it's a meritorious claim. And so that's why we believe that it continues to be fully enforceable as its procedural or remedial nature that it is, and that it doesn't do any constitutional harm. And part of that's because, the focus in any constitutional harm is on vested rights, not on an expectancy. And when you talk about, you being deprived of the day filing suit, there's no constitutional right to file suit on a particular day, nor is there a right under this contract to file suit on a particular day. That's an expectancy. And that's why matters that deal, with issues of procedure are applied retroactively on the date that a statute's enacted, because they just don't cross that line of interfering with vested rights.
And Ms. Flowers, I know you're getting close to the end, but maybe I'm looking at this rather simplistic, but I think Menendez does apply. And I want to give you the opportunity, if you look at Menendez as a whole and what it stands for, very clearly that it implicates not only the issue of, the way I see, as I indicated before, there is a delay in bringing suit. I know you stepped that aside saying it's only a short period of time, but nonetheless, there's a delay. And then it also, in my opinion, implicates the issue of attorney's fees. That's two things that, and Menendez was very, very broad in the sense that about it was broad language of, quote, implicating attorney's fees. So I see Menendez as instructive in this case, and I just have difficulty following your position in terms of that this is clearly doesn't follow the requirements of Menendez. So help me out, Ms.
Sure.
Brown.
So I previously didn't have the opportunity to really get to addressing the attorney's fee issue. This statute is unlike Menendez in that Menendez, the purpose of the delay was in order to change vested rights and create penalties. The reason for the delay was tied to a change in how you determined that a payment was overdue. And we're talking about the no-fault statute, the purpose of which is to provide almost immediate payment to claimants so that they can take care of themselves. So the reason for the delay was because of changing when benefits were overdue. So that extended the time before a cause of action would accrue. It also had in there an attorney's fee safe harbor. It extended the time for which attorney's fees could start to accrue because that was part of the delay in the pre-suit process. So these substantive vested rights were intertwined with the pre-suit notice in Menendez. That is not so in this case. The mere filing of the notice of intent to initiate litigation changes nothing about the claim for coverage under the policy or the amount of damages that are claimed at the policy. The vested right to attorney's fees is not changed in any way by this statute. What subsection 8 addresses is the entitlement to an amount of attorney's fees. Under subsection 8, every insured still has the opportunity to recover 100% of their fees, just like in any case that insured goes into with the vested right to recover 100% of their attorney's fees. But if a proposal for settlement comes along, there's a chance they're not going to recover 100% of their attorney's fees. If the insurer serves him with a Danis or DeSalvo letter and tries to cut off fees as of the date of that offer, they're not going to recover 100% of their fees. So nothing about this statute takes away the vested right to recover 100% of fees. What this statute does is codify other means by which the amount of the fees can be affected.
Well, it could be argued, Ms. Flowers, that it creates a category of fees as to which the claimant can recover 0%.
There is an opportunity to recover zero, just like
it's an opportunity. This is an opportunity to recover zero. I get it. You're right.
There's a proposal for just like there's a proposal for settlement.
Yeah.
Your Honor, if I can just close briefly,
Sure.
We are also interested in a written opinion, and not only that, if the court were not to focus on subsection 3, we would hope that the court would certify a question of great public importance to the Florida Supreme Court. This is an issue that's very important, not only to policyholders, but insurers and anyone who wants to obtain first-party property insurance in the state of Florida, and one that the legislature, is illustrated by its upcoming special session, is placing a lot of emphasis and concern on. For the sake of the great public importance, we would ask that the question be certified if you don't rule solely on subsection 3. Thank you, Your Honors.
Thank you all. It's very well argued, and we'll get back to you. So in order to leave, you click the leave button in the bottom part of your screen, and you'll go off in the ether. Thank you, Ms. Flowers.
Thank you all. Bye-bye.